of today's webinar on a very timely, very relevant, and an extremely controversial topic, the Anti-Terrorism Bill. So thank you for joining us today. If you will settle down comfortably now, we will begin our program. May I request everyone to pause and bow our heads for a short prayer. Our most merciful God, we welcome you in our weakness. We come to you in our fear. We come to you with trust, for you alone are our hope. We place before you the disease present in our world. Turn to you in our time of need. Our most merciful God, bring wisdom to doctors, give understanding to scientists, endow caregivers with compassion and generosity. Bring healing to those who are ill. Protect those who are most at risk. Give comfort to those who have lost a loved one. Welcome those who have died into your eternal home. Stabilize our communities. Unite us in our compassion. Remove all fear from our hearts. Fill us with confidence in your care. Amen. Let us now place our right hand on our chest and join in singing the Philippine National Anthem. Thank you. At this point, may I request the president of MAP, who is the senior partner and ex-com member of Accra Law, Attorney Francis Lim, to deliver his welcome remarks.
Thank you very much, Maan. Good afternoon to everybody. I hope that you and your families continue to be healthy and safe while the country is on a continued lockdown. On behalf of the MAP Board of Governors and the National Issues Committee, I welcome all of you to the first webinar on the Anti-Terrorism Bill. Thank you, Chair Risa Mantaring, Vice Chair Romy Bernardo, and Governor in charge Saito Tanco for organizing this online forum. Many thanks to our speaker, former Supreme Court Senior Associate Justice Antonio Tony T. CARPIO, for graciously accepting our invitation to speak before us this afternoon. I understand that there are around 255 registrants, excluding those who are joining us via Facebook. And I must say that this is one of the better attended online fora that we have organized during this pandemic. The National Issues Committee is holding 2 sessions on the Anti-Terrorism Bill to enlighten MAP members and our guests on what the proposed law is all about and its possible effects on our citizens, including our businessmen. The second session will be held next Wednesday, June 24, from 2 p.m. to 3:30 p.m. with no less than the principal author of the bill, Senator Panfilo P. M. Lacson. Please block off your calendars. Undoubtedly, the Anti-Terrorism Bill, which has been thrust upon us in the midst of the present pandemic and is now awaiting signature by President Duterte, has generated a lot of attention. There's a myriad of questions. What is this proposed law all about? Should we be concerned about any provisions of the bill? And if so, what are those provisions? What are considered acts of terrorism under the proposed law? Are mass actions like EDSA 1 and 2 considered acts of terrorism under the bill? Remember also that in the recent past, an Austerplatt matrix was released by Malacanang, I think, in 2018. This matrix, which is reportedly based on intelligence information, lists persons allegedly conspiring to discredit the present government. If a person is included in the list, can he be arrested for being a terrorist under the bill? Can a person be detained on mere suspicion? Does the bill resurrect the dreaded arrest, search, and seizure order, or ASO, during the Marcos years? Can an organization like the Management Association of the Philippines be tagged as a terrorist organization without any court intervention? What is the effect on the directors, officers, and employees if their corporation is tagged as a terrorist group? Can they be detained without the benefit of a warrant of arrest issued by a court of law? Can we suffer the same fate as Senator De Lima under the proposed law? Is it true, as reportedly stated by Senate President Soto, that if the bill becomes a law, there is no more need to declare martial law? What does this really mean to ordinary citizens like you and me? These are just some questions that arise from the proposed law. I am sure there is a host of other questions from today's participants. We're lucky, extremely lucky indeed, that we have no less than former Supreme Court Senior Associate Justice Tony Carpio with us today. Justice Carpio, who needs no introduction at all, will discuss the salient features of the bill and try to answer questions from us. In closing, thank you one and all for attending this webinar. And thank you most especially to our speaker, Justice Tony Carpio, for participating and sharing his time and expertise with us. Keep well, everyone. Enjoy the webinar. Maraming salamat at mabuhay ang Management Association of the Philippines.
Thank you very much. Thank you, President Francis, for setting the tone and asking some of the many questions that I'm sure are in the minds of our participants today. I just want to emphasize the following important house rules before we start the webinar. As participants of this webinar, we'd like to inform you that you are automatically muted and your camera and video also was automatically turned off. Please submit your questions through the Q&A button that you see on your screen on the lower side. You will only be able to view the speaker and his presentation, but you will not be able to view the other participants. And finally, in case you lose connection, please join again by repeating exactly what you did earlier in logging in. Now, in line with the MAP policy, we will dispense with a lengthy introduction of our speaker, who truly does not need any introduction in the first place. So may I now call our speaker, former Senior Associate Justice of the Supreme Court of the Philippines. Please welcome retired Justice Antonio Tony T. Carpio.
Thank you, Maan. Good afternoon to everyone. Thank you, MAP, for inviting me to this webinar talk on the Anti-Terrorism Act of 2020. I am objecting to the Anti-Terrorism Act of 2020 because of several provisions in the Act that are unconstitutional. Under the Constitution, the right against unreasonable searches, or rather, the right against unreasonable arrests, is an inviolable fundamental right. The Constitution uses the word inviolable. The Anti-Terrorism Act demolishes this inviolable fundamental constitutional right. The Constitution declares that the right of the people, and I quote, to be secure in their persons against unreasonable seizures of whatever nature and for any purpose shall be inviolable, end of quote. Seizures include arrest. So it means that in arrests of whatever nature and for any purpose, whether it is arrest for ordinary crimes or for serious crimes, the right of the people against unreasonable arrest is inviolable. To guarantee this inviolability against unreasonable arrests, the Constitution erected two fortresses. The first fortress is that only a judge can issue warrants of arrest. The second fortress is that warrants of arrest must be issued only upon probable cause. Now let's go to the first fortress. Only a judge can issue warrants of arrest. Section 2, Article 3 of the Constitution, the present Constitution, mandates, and I quote, no warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, end of quote. Now, as a background, under the 1935 Constitution, only judges were authorized to issue warrants of arrests. The 1973 Constitution changed this and authorized executive officials to issue warrants of arrest. The result was the notorious ASOS, the Arrest, Search, and Seizure Orders issued by the Secretary of National Defense during the martial law. The framers of the 1987 Constitution vowed never again and reinstated the provision in the 1935 Constitution that only judges can issue warrants of arrest. So there is no doubt whatsoever, under the present Constitution, only a judge can issue a warrant of arrest. This first fortress must be inviolable. Now, what has the Anti-Terrorism Act done? The Anti-Terrorism Act has demolished the first fortress and reinstated the ASOS of the martial law period. Section 2 of the Anti-Terrorism Act, with the telltale heading, detention without judicial arrest, without judicial warrants of arrest. Section 29 provides, any law enforcement agent or military personnel who, having been duly authorized in writing by the Anti-Terrorism Council, has taken custody of a person suspected of committing any of the acts defined and penalized under sections 4 to 12 acts of terrorism and of the Anti-Terrorism Act shall not be liable if he detains a person for a total of 24 days without filing a judicial charge. Now, Section 29 refers to warrantless arrest outside of Rule 113 of the Rules of Court on warrantless arrest, because any law enforcement agent or any citizen for that matter can effect a warrantless arrest under Rule 113 without written authority from anyone. If the law enforcement agent needs a written authority from the Anti-Terrorism Council to effect a warrantless arrest under Rule 113, that will defeat the purpose of warrantless arrest, where time is of the essence. Under Rule 113, the crime is already being committed in the presence of the law enforcement agent. And if he still has to secure the written authority from the Anti-Terrorism Council to arrest the offender, then that would be senseless. Clearly, the written authority referred to in Section 29 is not for the purpose of effecting warrantless arrest under Rule 113. The written authority of the Anti-Terrorism Council is necessary to arrest a person suspected of terrorism outside the situations wherein warrantless arrests are allowed under Rule 113. This was explained clearly by the principal author of the Anti-Terrorism Act, Senator Panfilo Lacson, and I will elaborate on this later. The Anti-Terrorism Council is, of course, a purely executive body under the control of the President, composed of 8 cabinet secretaries and the executive director of the Anti-Money Laundering Council. This is obviously unconstitutional, since the present Constitution allows only a judge to issue a warrant of arrest. And under the Anti-Terrorism Act, an executive body composed of cabinet secretaries are now allowed to issue orders or warrants of arrest. Now let us go to the second fortress. Warrants of arrest must be issued only upon probable cause. This is the term used in the Constitution, probable cause. Again, the Anti-Terrorism Act has demolished the second fortress. Probable cause means the judge has reasonable grounds to believe, based on affidavits of the complainant and his witnesses, that a crime has been committed and the person to be arrested probably committed the crime. In short, if the judge believes that no crime has been committed, he cannot and should not issue a warrant of arrest. Now, during the Senate deliberations on the Anti-Terrorism Act, Senator Lacson, the principal author of the Anti-Terrorism Act, explained, and I quote, "Hindi na rin po natin pinalitan yung provision sa citizens' arrest in this case. Kaya lamang, ang in-expand natin ay yung period. In ordinary crimes, hindi pwede yung nasa planning stage, hindi naman niya ginawa, hindi naman siya nag-commit ng crime, pero dahil itong tinawag nating inchoate offense, hindi pa nangyari, nasa simula pa lang, pwede na natin arestuhin because we want to be proactive because this is a new phenomenon." End of quote. In short, under Section 29 the Anti-Terrorism Council is authorized to order the arrests of any person, even if he or she has not committed any act of terrorism. In the exact words of the principal author of the law, even if hindi naman siya nag-commit ng crime, hindi pa nangyari, pwede na natin arestuhin. The justification, according to Senator Lacson, is we want to be proactive. Section 29 does not provide standards or limitations to the power of the Anti-Terrorism Council to issue arrest orders. It's just like the ASOS of the martial law era. Section 29 does not require probable cause before the ATC, the Anti-Terrorism Council, can issue an arrest order. Clearly, the Anti-Terrorism Council can issue an arrest order even without probable cause, demolishing completely the second fortress erected by the Constitution to ensure that the guarantee against unreasonable arrests is inviolable. The House of Representatives adopted in toto the Senate version authored by Senator Lacson, and thus the House is deemed to have adopted also the intent and interpretation of the Senate on Section 29. Obviously, any arrest order not founded on probable cause is unconstitutional. Now, under Section 25 of the Anti-Terrorism Act, the Anti-Terrorism Council is authorized to designate any individual or organization as a terrorist or engaged in terrorism. Let me quote Section 25. The Anti-Terrorism Council may designate an individual, group of persons, organizations, or associations, whether domestic or foreign, upon a finding of probable cause that the individual commit or attempt to commit or conspire in the commission of the acts defined and penalized under Section 4 to 12 of the Anti-Terrorism Act. Clearly, the Anti-Terrorism Council has the power to designate an individual or organization as a terrorist or engaged in terrorism. Now, once so designated, the individual can now be arrested upon order of the Anti-Terrorism Council because the individual is engaged in terrorism. You are now labeled as a terrorist, of course, you will be arrested because terrorism is a crime. Likewise, any and all members of the organization so designated can be arrested upon order of the Anti-Terrorism Council because under Section 10 of the Anti-Terrorism Act, mere membership in such organization is a criminal offense. Let me quote Section 10. Any person who shall voluntarily and knowingly join any organization, association, or group of persons, knowing that such organization is organized for the purpose of engaging in terrorism shall suffer the penalty of imprisonment of 12 years, end of quote. Now, the penalty for mere membership in an organization designated by the Anti-Terrorism Council as engaged in terrorism is 12 years. That is bailable, but the accused can be placed in house arrest, negating his constitutional right to bail. Because if the person is charged with an offense not punishable by reclusion perpetua, 12 years, it's below reclusion perpetua, that is bailable as a matter of right. However, for those who recruit members to such an organization, the penalty is life imprisonment without parole. It's a non-bailable offense if evidence of guilt is strong. Life imprisonment means you remain in prison throughout your physical life. And under the Anti-Terrorism Act, there is no possibility of parole. This life imprisonment is different from reclusion perpetua in the revised penal code. In the revised penal code, reclusion perpetua ranges from 20 years and 1 day to 40 years, after which you are released from prison because while it's called reclusion perpetua, it's not really imprisonment for your physical life. But in the Anti-Terrorism Act, the penalty is life imprisonment. You will be imprisoned throughout your physical life. The question is, how will the Anti-Terrorism Council make such designation? How will it designate you a terrorist or your organization as engaged in terrorism? Is a hearing required where the individual or organization is represented? The only requirement under Section 25 is upon probable cause, which means that the council, the Anti-Terrorism Council, must have reasonable grounds to believe, based at least on affidavits of the government witnesses, that the individual or organization is engaged in terrorism. However, probable cause does not require a hearing where the individual or organization can be heard to rebut the witnesses of the government. Thus, under Section 25, the Anti-Terrorism Council can make the designation ex parte without any hearing. Now, is this constitutional? This, I consider, is unconstitutional. Now, the Constitution provides, and I quote, the right of the people to form associations for purposes not contrary to law shall not be abridged, end of quote. This is the freedom of citizens to join any association of their choosing, provided the purpose of the association is not contrary to law. The Constitution also provides that, and I quote, no person shall be deprived of liberty without due process of law, end of quote. You put these two provisions together, and that means that before the ATC can designate a person or organization as a terrorist or engaged in terrorism, that person and members of the organization must be given due process. There must be a hearing, because once you are tagged as a terrorist or as a terrorist organization, you can be arrested already. So you can be deprived of your liberty. So that will be against the constitutional guarantee that no person shall be deprived of liberty without due process of law. So the Anti-Terrorism Council must have a hearing where the person to be tagged as terrorist or the organization to be labeled as terrorist must present their side. And if they are still declared as terrorists, they can appeal. But here, under Section 25, they're not present. The only time they will know is when they're already arrested. Due process means a hearing where the individual or organization can present their side to rebut the allegation that they are engaged in terrorism. Absent this due process, the designation of the individual or organization as engaged in terrorism will result in the deprivation of liberty of the individual and the members of the organization. They are deprived of liberty without due process, and that is unconstitutional. In short, since Section 25 allows the Anti-Terrorism Council to designate an individual or organization as engaged in terrorism without a hearing, thus resulting in deprivation of liberty, Section 25 is unconstitutional. Let me give a graphic example of the application of Sections 10 and 25 of the Anti-Terrorism Act. Suppose there is a former senator, let us call him Mr. X, who is designated by the Anti-Terrorism Council as a terrorist under Section 25 because he allegedly engages in acts intended to cause extensive damage to public places or private properties for the purpose of creating an atmosphere of fear. That is an act of terrorism under Section 4, that is punishable with life imprisonment, non-bailable. The ATC orders the arrest of Mr. X and is taken into custody by military personnel. Mr. X's relatives filed a petition for habeas corpus before the RTC on the 4th day of the arrest. The judge will issue the writ of habeas corpus and require the custodian of Mr. X to bring Mr. X to the court on the 8th day of the arrest. When the judge asks the custodian, why is he detaining Mr. X, the custodian will produce the written paper from the ATC designating Mr. X a terrorist and ordering his arrest. And unless Section 25 of the Anti-Terrorism Act is declared unconstitutional, the judge will have no recourse but to dismiss the petition for habeas corpus because Mr. X is being detained pursuant to law, and the government custodian has still 6 days to detain him before filing a criminal case in court, or even 16 more days if the custodian secures an extension, because a total of 24 days is allowed. On the 24th day of the arrest, the Anti-Terrorism Council, through the prosecutor's office, files a criminal case against Mr. X for terrorism. The judge issues a commitment order because the judge finds probable cause to the non-bailable charge. Mr. X can file a motion for reconsideration, a motion to quash, appeal to the Court of Appeals, all the way to the Supreme Court. But in the meantime, as long as the warrant of arrest is not lifted, Mr. X remains in detention, just like Senator Laila de Lima. That's the effect of Section 25 of the Anti-Terrorism Act. Let me go to another topic. Senate President Vicente Soto III recently said, hindi na kailangan ng martial law kapag napasa na namin itong anti-terror bill. I agree with Senator Soto that upon enactment into law of the Anti-Terror Act, martial law will be superfluous. Under the Constitution, the President can declare martial law and suspend the writ of habeas corpus for not more than 60 days. Not more than 60 days. Congress, by majority vote, can revoke the declaration within 48 hours from its declaration. In contrast, the Anti-Terrorism Act, once enacted into law, remains in the statute books forever until repealed by Congress or invalidated by the Supreme Court. Under the Constitution, when martial law is declared and the privilege of the writ of habeas corpus is suspended, a person arrested for rebellion must be charged in court within 3 days from arrest. Otherwise, he shall be released. When he is judicially charged within 3 days, he can ask for bail if he is charged for an offense not punishable with reclusion perpetua, or if he is charged with an offense punishable with reclusion perpetua, he can ask for bail if evidence of guilt is not strong. Now, under the Anti-Terrorism Act, a person arrested for terrorism and detained for a total of 34 days before a judicial charge is required to be filed, whether he is charged for an offense punishable with life in prison or not, he stays there for 24 days without any judicial charge. So that's longer than the 3 days under martial law. Now, the person arrested for terrorism can at any time during the 24 days, of course, file a petition for habeas corpus. Right after arrest, he can do that. But once the custodian shows the written authority of the Anti-Terrorism Council to the judge that there is an order for his arrest because he is a terrorist, then the judge will be compelled to dismiss the petition because the person is being detained upon lawful order pursuant to law. That will be the situation unless Section 29 is invalidated by the Supreme Court. In short, with the Anti-Terrorism Act as part of the law of the land, it is as if the Philippines is permanently under a situation worse than martial law. My last point is the effect of the Anti-Terrorism Act on the presidential elections in May 2022. The Anti-Terrorism Act punishes speech, whether written, verbal, or visual, that incites others to commit terrorism. That's inciting to terrorism. The Anti-Terrorism Council, without a judicial warrant, can order the arrest of anyone for inciting to terrorism even before the incitement is made, because the Anti-Terrorism Council is a proactive body, as explained by Senator Lacson, the principal author of the Anti-Terrorism Act. The arrested person can be detained for a total of 24 days. This person may be a columnist, maybe a reporter. So after 24 days, if there is no charge, he has to be released. But after a few days, he can be arrested again. In the 24-day cycle, will repeat and repeat, keep on repeating. Unlike in habeas corpus, where the rules of court says if the person is released by the court, he cannot be rearrested again for the same charge unless there is an express order by the court. There is no similar provision in the Anti-Terrorism Act. The Anti-Terrorism Act will have a devastating effect on freedom of speech and freedom of the press in the May 22 presidential elections. The Human Security Act of 2007 provides that the act is automatically suspended 1 month before an election and 2 months after the election. That's automatic. That's in the Human Security Act. Under the Anti-Terrorism Act of 2020, which repeals and replaces the Human Security Act, there is no such provision of suspension. So the Anti-Terrorism Act continues during the entire election period. In conclusion, let me end here. If we do not want to experience a contraction of our civil liberties, we must all work to have the objectionable provisions in the Anti-Terrorism Act invalidated by the Supreme Court or repealed by Congress. Vigilance is the price of freedom. With that, I end my presentation. Thank you for your kind attention.
Thank you very much, Justice CARPIO, for that very comprehensive, if quite scary presentation you just gave us. At this point, we will be going to the question and answer. And as I mentioned earlier, you can submit your questions through the Q&A button. Sorry, but due to time constraints, the webinar participants will not be able to be given the opportunity to ask the questions personally or to speak in front of the camera. I'd like to start with my own question. Justice Carpio, given that many countries around the world have some form of preventive detention for terrorism, is there any way that the Philippines can also have preventive detention, but within the framework of the Constitution and which respects the rights of the citizens?
Yes, of course. We cannot compare ourselves with other countries because they have different constitutions. We're bound by our constitution, and all our laws must abide with the constitution. But I think we can draft a law that complies with the constitution and satisfies the requirements of our security people, the defense and security departments of government. I think we can do that. I have looked at all the provisions, and I think it can be solved if only this can be discussed by everyone. I mean, unfortunately, because of COVID, we do not even know that the Senate already approved it, and then it was fast-tracked in the House. They were not even allowed to introduce amendments in the House. So we're stuck with this now. And I think it's a very defective law, and there are many unconstitutional provisions. But yes, we can draft a law that protects our country against terrorism within the bounds of the Constitution.
So I take it then, Justice Carpio, that you were not consulted by the House and the Senate in their drafting of this bill?
I think, like everyone else, I was surprised.
Well, if going on the theme of not throwing out the baby with a basin and bath water, what provisions of the current proposed anti-terrorism law do you think are useful reforms and an improvement over the legal framework of the current Human Security Act? In other words, what would you retain? We've already heard about some of the provisions that you definitely would like to get rid of, but what would you retain?
Well, Section 4 defines what are acts of terrorism. This is the heart of the law. And it has 5 categories of acts of terrorism. Of the 5, I can live with the 4.
Okay.
A to E. Letter A, it says, the following are acts of terrorism prohibited by law, penalized by law. Acts that engages, anyone who engages in acts intended to cause death or serious bodily injury to any person or endangers a person's life. In other words, anyone who engages in acts that endangers a person's life. Any person who engages in acts that endangers a person's life. That's very broad. But there is a polatilia in the Section 4. All of these acts, categories of acts, must be for a purpose, intended to create an atmosphere or message of fear, intended to intimidate the general public. So you commit any of these acts, and if the intention of the acts are fall under any of this, then it's terrorism. But letter A is so broad. I mean, I can, for example, assuming the law is in effect now, and there are students today, this afternoon, in UP who are demonstrating against the law. And they are demonstrating en masse, so they're engaged in an act that endangers the lives of other people because COVID, the coronavirus, is a transmissible disease. So they're endangering the lives of other people because they are conducting a mass event that they are endangering the lives of the people. And that creates an atmosphere of fear. So they are already committing an act of terrorism under this provision. If you drive your car recklessly, you can be arrested, and even for terrorism, because you're endangering the lives of other people, spreading fear. It's very broad. If only this category A will be deleted, then we can live with it, because all the others are not usual acts, like you manufacture weapons of mass destruction, nuclear, biological. That's not a normal act. You extensively damage critical government infrastructure. You don't do that. So it's only in Section 4A where there can be a very broad interpretation. Also, under under the Constitution, in case of martial law and the writ of habeas corpus is suspended, a person upon arrest must be charged within 3 days. So there is this question whether that is the maximum that can be allowed. You have to file the charge in court before the end of 3 days. Otherwise, it will become unconstitutional because of the threshold in case of suspension of writ of habeas corpus. But I do understand that maybe 3 days is not really sufficient to gather all the evidence. In other countries, it goes up to 15 days, 60 days. So can we find a solution that is compliant with the Constitution and satisfactory to our national defense and security officials? Yes, I can. I suppose we can. We can say within 3 days, you have to file a preliminary charge of terrorism with the court. And you have to prove to the judge that there is probable cause already, but the evidence is not strong enough, or you want to gather more evidence, but the evidence is strong enough for the charge to stick. But you see, the Constitution requires strong evidence in case of a non-bailable charge. If it is a non-bailable offense, but the evidence is not strong, the case can still continue, but you have to be on bail. So we can satisfy the requirement that the charge is judicially filed within 3 days, but the defense official will ask for an extended time to gather more evidence and file the final charge within 24 days, total of 24 days. That can be done because you're complying with the Constitution. There is a charge within 3 days. So this can be done. I mean, all of this really can be done if we just look at it carefully. Also, this inciting to terrorism, the doctrine in the Supreme Court is inciting to rebellion is allowed. I mean, that's a crime, but that becomes punishable only if the incitement invites immediate lawless action. In other words, it's so, the incitement is so great that it immediately invites lawless action. So if you put those qualifications, then we can proceed with incitement to terrorism. But as it is worded now, the judge will look at it and look at what you have written as a columnist and say, oh, this is inciting to terrorism. And that means you can be arrested already. So there are safeguards. Supreme Court has provided safeguards. Of course, they are deemed written into the law already, but just to clarify so that the judge or the arresting officer will understand what they're doing, let's put it in the law.
Justice Carpio, do we have to wait for this bill to become a law, to be signed by the president, or for him to allow it to lapse into a law before this can be challenged in the Supreme Court? There's a question from Connie Madarang. Has there been a petition filed by any group to the Supreme Court to declare the Anti-Terrorism Act as unconstitutional?
Not that I know of, because you can question this Anti-Terrorism Act once it becomes a law. That means upon signing by the president and publication, well, depending on the effectivity date of the publication.
Another question from Ben Tunungbayan. Justice Carpio, your discussion of the unconstitutionality of warrantless arrest and the usurping by the ATC of the power of the courts in issuing arrest warrants is very plain and clear. Why would the large majority of our legislators, who are mostly lawyers, pass a law with that kind of defect? I cannot possibly think that they do not understand our Constitution. Thank you.
Well, that's surprising also. I read the deliberations in the Senate, and nobody objected to that statement of Senator Lacson that we can arrest anyone even before the crime has been committed. I think I don't know why there was no question on that, but I think that could have been corrected in the House. But then there was a closure in the House. Nobody was allowed to introduce amendments. So we're stuck with this now.
Question from Rogelio Avenido. Is it still possible to submit the law for public hearing prior to signing by the President? Is there a mechanism for that?
There's no mechanism for that. You just have to wait for the President to sign it or allow the law to lapse, and then we question it before the Supreme Court. In the meantime, while we are questioning it in the Supreme Court, Congress can act. The House or the Senate can pass a bill to correct the Anti-Terrorism Act. They can introduce amendments right there after it becomes a law. They can start the ball rolling. So there will be a two-pronged attack, one in the Supreme Court and one in Congress where they're amending it, proposing amendments.
A question from Tomasa Lipana. Why do you think Congress rushed the approval of the bill? Is there a compelling reason, for instance, serious terrorism threats that the government knows, which we in the public are not aware of?
Well, it is clear that it was rushed because there was a certification from the President of the urgency of the bill. Now, what is not clear is the reason behind it. So we can only speculate, but the first part of the question is correct. It was rushed because there was a certification that it is an urgent bill. That's why they did not have to observe the 3-day requirement where there will be 3 readings in 3 different days. So we can only speculate on why it was rushed.
A question from an anonymous attendee. Will there be a remedy in international law, assuming that the Congress and Supreme Court do not act on protecting the guaranteed constitutional rights of the Filipinos, being a sovereign state?
No, I don't think there will be a remedy, unless, of course, the acts that are, if crimes against humanity are committed in the course of implementation of the act.
Question from Arps de Vera. The council that will approve who are considered to be terrorists are all cabinet members who obviously will have little time to vet those recommended to be arrested as terrorists. Couldn't we instead have impartial members who will have the time to act as an oversight, to include Commissioner of Human Rights, a retired justice, retired general, the armed forces or police? And can the oversight group also recommend filing of abuses?
Well, that is the reason why only a judge can issue a warrant of arrest, because he is deemed to be impartial. I mean, you cannot give the authority to warrant of arrest to the one investigating the crime, the police, or to the military. Of course, they will say there's a ground to issue the warrant of arrest because that's their job. So it has to be an impartial body. That's why it's given to a separate branch of government, the judiciary. But it's good to have an oversight.
And a continuing question from Arps de Vera. Will there be someone, a sort of ombudsman, who will regularly inspect prisoners and ensure that no torture is being applied and that the arrested are treated correctly under the proposed bill?
Well, there is no provision for that, although it says here that the anti-torture bill will be applicable and will be observed. There's a separate bill for that.
An expert on international security is of the opinion that this bill is long overdue because the Philippines has lagged far behind its regional neighbors as far as anti-terror legislation is concerned, and that Philippines still has terror groups and serves as sanctuary and training area for terrorists from all over this region and beyond. Do you believe that the current Human Security Act of 2007 is sufficient to address terrorism? And if not, what amendments to the 2007 HAS would you recommend in lieu of the new anti-terrorism bill?
I think as Senator Lacson and Senator De La Rosa explained in the Senate, their problem really is when they arrest a terrorist, they have to charge him in 3 days. Sometimes they don't have enough evidence that will constitute strong evidence so that the terrorist will be denied bail. They need more time. I think from what I gather from their deliberation in the Senate, that's the core of the matter. They were for, in fact, Senator Bato said, we caught this guy, but we needed more evidence to make it strong so we can hold him permanently. But we could not. We did not have enough time, so we had to release him. So that was the fear that was placed before the senators. So I think we can find a way to solve that, the one I explained. File that preliminary charge within 3 days, ask the court for an extension of time to hold him. And we comply with the Constitution. A charge was filed within 3 days.
So in other words, your opinion is that the 2007 Human Security Act is sufficient if it is revised or...
Well, it can stand improvement, and I agree that that is the concern of the defense and security officials, and I agree with that because it's difficult really to compile a strong evidence in 3 days. But remember, before you arrest this guy, you have already conducted surveillance. You already asked the Court of Appeals for authority to wiretap him. So you must have everything already. But of course, sometimes you arrest him right there in the field and just encounter this guy for the first time. So there are many variations. So we have to cover all of that. But I think we can just amend the Human Security Act of 2007, or we can continue with this act, but delete the provisions that are unconstitutional. We can find a solution that will comply with the requirements of our national security officials and with the requirements of the Constitution.
In his opening statement, Attorney Francis Lim was asking what are the specific instances when activism is considered terrorism under the anti-terror bill. Are there specifics, or is it too broad and wide that you can't enumerate?
The one I explained to you earlier.
Yes.
Supposing today there's a rally in UP against the Anti-Terrorism Act, assuming this is a law already, they could be arrested because they're endangering the lives of people, because that would spread the virus and that will spread fear. That would fall under the Anti-Terrorism Act. So my opinion is just delete letter A, and I think we're ready to go with section 4, because letter A is just too broad.
Are mass actions, for instance, like EDSA 1 and EDSA 2, considered acts of terrorism under this bill? Would it fall under acts of terrorism?
By itself, it's not, because that's guaranteed by the Constitution. Freedom to associate, freedom to rally. It becomes an act of terrorism if the intention is to spread an atmosphere of fear. So it's a very broad thing, because anything can be fearful to society. So I think we have to really also refine a little bit this intention.
Question from Rex Drillon. Recently, we have read reports about fake Facebook accounts. My own son discovered that there are 5 fake Facebook accounts bearing his name. His fear is that these accounts bearing his name might be used by sinister forces by putting incendiary messages that will be interpreted as terrorist acts and put him in danger. How do we protect innocent citizens from these sinister forces?
That's very real, because inciting to commit terrorism is a crime. That's 12 years imprisonment. So if they fake your account and they put words into your mouth, they say that let us burn all the government's infrastructures in the city of Manila, then that's inciting to terrorism. But you do not do it; somebody else did it. So, but in the meantime, you will be arrested, and the case will go up all the way to the Supreme Court. You stay under detention. So,
In other words, the same fate.
yeah.
Yes, go ahead, please.
Just exactly like Laila de Lima.
Okay. Additional questions from Risa Mantaring this time. Some lawmakers, she can't recall exactly who, have claimed that there are legal precedents for exceptions to the Constitution. Is this true? Do you find this to be true? And under what circumstances can a law be enacted as an exception to the Constitution?
I do not know of that. It's the first time I've heard that. But,
Okay.
like for example, the Constitution says no warrant of arrest shall be issued except by a judge. But the Supreme Court has adopted Rule 113. If the crime is committed in the presence of a police officer, the police officer can arrest him even without a court warrant. I mean, the Supreme Court can carve out exceptions, but it has to be the Supreme Court. Because, it's logical. It's the crime is committed in your presence, the guy is there, the police officer is there. You arrest him. You don't need a court warrant. If you look at this strictly, it will not be in accordance with the provision of the Constitution that you cannot arrest anyone without a court warrant. But that is allowed because the Supreme Court is authorized under the Constitution to adopt rules to enforce the constitutional rights. And this is an enforcement of the constitutional rights. That's how the constitutional rights are enforced. There must be an actual commission of the crime in presence of the police officer.
Question from an anonymous attendee. It was mentioned that the Anti-Terrorism Council can designate organizations as terrorist group organizations. Does this apply to employees as well? Meaning mere employment in a company designated as terrorist organization may be considered engaging in terrorist activities and may cause the employee's arrest?
The organizations that are intended to be covered here are normally associations. They are not companies, because a company, you look at the articles of incorporation, it's for business.
Mm-hmm.
So if the company, however, is a legitimate business, but the officials are designated as terrorists, it doesn't mean that the other employees are terrorists unless they themselves are terrorists.
Will the law be effective while it is being challenged in the Supreme Court, assuming it will be challenged in the Supreme Court?
Yes, it will be effective unless the court issues a PRO. Unless the court, in the meantime, suspends the implementation, it will be effective immediately upon effectivity, date of its effectivity.
So what would be our recourse or remedy in case the president doesn't veto the bill and it subsequently becomes a law?
A remedy is to lobby with our congressmen and senators to amend the Anti-Terrorism Act.
Can they amend it after it has been already signed into law by the president?
Yes, yeah. They can, any law can be amended, but subsequent.
Okay. A question from Sandy Tablan Paredes. Can this anti-terrorism bill be a form of an emergency power for the president? since he appoints all members of the ATC, only that such powers is not temporary. The bill in itself seems to not pass the completeness test. They can draft the IRR without any limits or boundaries. Who drafts the IRR, by the way, Justice Carpio?
Well, the IR is drafted by, I think the IR will be drafted by the members of the council, by the Anti-Terrorism Council.
So it will be drafted by them.
Yes.
Okay. Question from Sofia Abrogar. Given the tendency towards selective justice in the country, what sectors do you think will be made most vulnerable should this bill be passed into law?
Well, of course, the activists, and my fear is that this could be used in the 2022 elections.
Question from Sandy Tablan Paredes. Can this law be amended through a people's initiative?
Yes, it can be amended through a people's initiative. But of course, it's very difficult to do that. But if this really generates anger from the people, yes, that can be one avenue. In fact, the people can pass a law through people's initiative to remove entire sections of this bill.
Okay, another question from Anonymous. If the ATB becomes a law, will rallying against the anti-terrorism law constitute terrorism?
It should not, unless they say that's the problem there. Unless they say it's spreading fear. It's the purpose of that is to create an atmosphere of fear.
Mm-hmm.
So that's where the vagueness comes in.
Another question. Would the retainment of the clause of the automatic penalty of 500,000 pesos per day upon acquittal, penalty to the law enforcer who wrongly charged the person, would the 500,000 pesos per day penalty upon acquittal be enough safeguard against abuse? Because that was deleted.
No, I do not believe that law enforcement officials should be penalized that way. Because if you put those provisions, they will just not act.
So you do agree
find
with
another way to discipline them if they abuse.
Okay, so you're in agreement with the deletion of that provision. Question: is it possible to file for an injunction with the Supreme Court while it is pending with them?
Yes, as I said, the court may, if it wants, may suspend the implementation of the law. That has been done before.
Another question from Attorney Francis Lim. There was an ouster plot matrix indicating persons or groups allegedly conspiring to discredit President Duterte, released by Malacanang in 2019. Could this report, which is allegedly based on intelligence information, be the basis of warrantless arrest under this new bill?
Yes, it can be, because that will be destabilizing our political the government. It will create an atmosphere of fear. It will intimidate. It will be an act to influence by intimidation the government.
Tony Lopez, who a member of MAP, considers the anti-terror bill as a done deal. The president does not even need to sign it to make it into law, as it lapses into law in 30 days. Tony says that this terror bill is no worse than what the rest of ASEAN countries have, and quotes Senator Tito Soto in enumerating the following: Bangladesh, 15 days, Indonesia, 21 days, extendable to 120 additional days, Pakistan, 30 days, Malaysia, 59 days, extendable to 2 years, Singapore 730 days to indefinite. What would you say to, what will you
Well, as I
comment?
said, they have a different constitution. We have a different constitution. We are bound by our constitution. And as I also said, that is the core of the problem, I think, of the military, of our security agencies, the period of detention. But I said there is a formula to solve that within the Constitution. You file a preliminary charge with the court, ask the court for an extension of the period of detention.
Well, Tony
Extension of the
Lopez,
period to file the final charge.
Tony Lopez also suggests that MAP ought to lessen focus on the anti-terror bill and opposing it vigorously. And he says that everybody should focus instead on the looming economic crisis, which will be the worst in our country's history. To quote him, the crisis will be the greatest terror of all, and not even 100 terror laws can solve it. Would you like to comment on that? Can you comment? Would you like to comment on that?
Well, I think we all live in Philippine society. Even if you're a businessman, you're a manager, you cannot close your eyes to these events. Your family will be affected. Your children are studying in school will be affected. Your relatives will be affected. We'll all be affected with this. This will affect the business environment.
Well, critics of the law have a retort to Tony Lopez's statement. They also ask exactly the same question. Why was there such a mad rush to get the anti-terror law amidst the COVID pandemic and economic crisis? I think that's self-explanatory. Another question from Rex Drilon. Can citizen groups like MAP and other organizations engage you and other retired justices, especially the retired chief justices, to appear with the Supreme Court in questioning the constitutionality of the Anti-Terror Act if it becomes a law? Are we still on?
Can you repeat your last question?
Okay. Question from Rex Drilon. Can citizen groups like MAP and other organizations engage you and other retired justices, most especially retired chief justices, to appear with the Supreme Court in questioning the constitutionality of the Anti-Terror Act if it becomes law? I think he's proposing that we engage you.
No, well, if it is signed into law, I have told my friends I will join a petition to question the constitutionality of this law. But I cannot act as counsel because there's a 1-year prohibition. I cannot appear before the Supreme Court because there's a prohibition under the law appearing in the agency where you worked 1 year before, after you retired or left office.
Can you just refresh on us, when does the 1 year expire?
October of next year. Of this year.
Of this year. Well, that's not too far off. We're already towards the end of June, July, August, September, October, 4 months. So Rex, we can engage justice at the end of October.
No, I mean, I plan to be a petitioner to question the constitutionality of the Anti-Terrorism Act, but I will not be a counsel.
Okay. Will the anti-terrorism bill be a part of the 2021 bar examination? Did you get that question? Will the anti-terrorism bill be part of the 2021 bar examination?
I really don't know because I'm not in charge. And even if I'm in charge, I cannot say so.
Okay. Question from Lot Ortiz Luis. Can you please elaborate further on the implications of this bill on the 2022 elections in curtailing the rights of the opposition and citizenry, considering our fast eroding confidence in our courts to protect these?
Well, there is a provision in the Anti-Terrorism Act, inciting to commit terrorism. Inciting means you incite by written words, by verbal words, or by visual acts. And if you do that to incite others to commit acts of terrorism as defined in Section 4, then you are guilty of, you're liable for inciting to terrorism. You can be arrested. The penalty is 12 years imprisonment. It's bailable, but then you can be under house arrest. So I think that creates fear in the mind of journalists, in the mind of reporters, even in the mind of the opposition. That's why in the Human Security Act of 2007, the act is suspended. The Human Security Act is suspended during the election period, so that you can freely express yourself. There's no fear. But that has not been carried over in the Anti-Terrorism Act that is about to become a law.
Justice Carpio, another question from Riza Mantaring. If the bill becomes law, can the Supreme Court nullify the unconstitutional provisions? Just the
Yes,
provisions?
it can. If they believe that they are in violation of the Constitution, they will.
But relative to this, a question from Nina Galang, from James Velasquez. As a co-equal body, do you think the judiciary will take action on this as it does encroach on their responsibility?
No, well, under the system of government, they are co-equal, but there is a check and balance.
Mm-hmm.
If either Congress or the executive, the president, commits an act that is against the Constitution, it's the Supreme Court that will say that act is not legal, not constitutional. It can be done.
From Nina Galang, for the law to be effective, does it have to wait for the formulation of the IRR?
The law, once it takes effect, because the law says this will take effect, let's say 30 days after publication, it takes effect.
So it takes effect even without the implementing rules?
It should take effect even without, but the actions will have to await. In other words, because the implementing actions are administrative in nature, they cannot amend the law, they cannot expand the law, they have to implement the law. That's why it's called implementing.
Mm-hmm. Okay, from Marianne Enriquez, Senator Lacson in a media forum earlier today said that the phrase having been duly authorized by the ATC in Section 29 was Senator Franklin M. Drilon's amendment in the 2007 Human Security Act, and this was merely retained in the proposed Anti-Terrorism Act of 2020. Your comments, please.
You need to say the duly authorized by the in writing.
ATC. Yes.
Well, the equivalent provision in the Human Security Act of 2007 provided for two limitations: that the ATC, the Anti-Terrorism Council, can authorize the arrest only in two instances. In instances where the Court of Appeals has authorized wiretapping, interception of wired or wireless communication, and the other case is in case of examination of bank deposits. So very limited. And in both cases, there is already court intervention. It was not a blanket authority to the ATC. It was pursuant to these two authorizations already from the Court of Appeals. But even then, the case that was brought by Harry Roque, remember, the spokesperson now, went to the court, first to the RTC all the way to the Supreme Court, questioning the constitutionality of the Human Securities Act. And that case that Harry Roque filed was dismissed on a technicality because they didn't have personality. So there was no ruling from the Supreme Court, by the Supreme Court, that section 29, the equivalent section, the Human Securities Act, was never declared constitutional by the Supreme Court. That's still an open question. The Supreme Court has not ruled. So the section 29 now is different from the section, from its equivalent provision in the Human Securities Act. And besides, there was never a Supreme Court decision saying that provision in the Human Securities Act is constitutional.
Another question from Cholo Miranda. Considering that this is a special penal law, I understand that no criminal intent is needed in order to find a person criminally liable. If a person happens to attend what he had initially thought of to be a peaceful rally, but such rally later on causes death or serious bodily injury, would that person be liable under the Anti-Terrorism Act as currently worded? Can you hear me, sir? May I repeat the question?
Yeah, please repeat the question.
Considering that this is a special penal law, I understand that no criminal intent is needed in order to find a person actually criminally liable. So if a person happens to be attending a rally, which he initially thought would be peaceful, and then it turns violent and causes death or serious injury, would that person then be liable under the Anti-Terrorism Act as it is currently worded?
Well, that is correct. It's a special law. Mens rea or criminal intent is usually not required unless the law itself says so. And in this section 4, it says, if you commit these acts, sections 4, 8, B, C, D, and E, and your intent is this, then that is terrorism. The law itself says it.
Could you, I know you mentioned it already earlier, but maybe you can explain a little further what this inciting to terrorism really means, because it seems to be a new law that has been created in effect, correct? I mean, it didn't exist before, inciting to terrorism.
Yes, this was not in the Human Securities Act. Yeah, this inciting to commit terrorism was not in the old law, in the Human Security Act. So if you write an article, you're a news reporter, and you incite others to commit an act of terrorism as defined in section 4. In other words, you tell them, let's destroy this telecommunication tower. That is inciting to commit an act of terrorism. Now, under the jurisprudence of the Supreme Court, that is not necessarily punishable because that may be part of freedom of expression. It becomes punishable only if it will incite imminent lawless action. In other words, if you say that among friends, I mean, where you cannot expect them to follow what you say, I mean, that would not be inciting to commit terrorism. So it depends on the circumstances. That's why the Supreme Court said it doesn't follow if you say those words, they are criminal acts. It must incite immediate lawless action.
A question from Pia Sophie Ditke. Justice, does the act apply to foreigners staying in the Philippines the same way as citizens of the Philippines? And also, could violations of the act take place outside of the Philippines? For example, by a Filipino demonstrating and spreading fear publicly in another country?
Yeah. It applies to a Filipino wherever he may be, whether he's in the Philippines or abroad. It applies to a foreigner if he's residing here, or even if he's abroad, but the intent, but the action has effect here. Let's say a foreigner is in Hong Kong directing the terrorist act here in the Philippines, he is also liable. There is a nexus.
Question from Tammy Lipana. You mentioned that the bill affects the freedom of press or freedom of speech. How do you think this affects election campaign speeches?
Well, it depends on what those candidates will say. I mean, if they attack the government very strongly, they might be charged of inciting to terrorism.
Question from Irma Tan. Are religious groups exempted from this law with regard to expressing their views, to pursue the truth, learn the facts, etc.?
There is no exception. It applies to all people here in the Philippines, even abroad, if the act takes effect here in the Philippines.
Justice CARPIO, there's a big elephant in the room, and an anonymous attendee would like to actually bring the elephant to the front. So this is a bit off topic, but what is your opinion about the guilty verdict just passed against Maria Ressa and her co-accused?
I beg to not to answer that now. I'm writing a column on.
Okay, and when will we expect your column?
Within the next 2 weeks.
Okay, so within the next 2 weeks, you will get your answer, Mr. or Miss Anonymous. Question from Pinky Ocampo. Do you recommend former or retired Supreme Court justices to be part of the ATC? Would it be a good idea?
Well, it will be a good idea if there are people there who are familiar with the protection of civil liberties. But the ATC must be a purely executive body. It should not issue warrants of arrest. That's my whole point. So if the warrant of arrest is issued only by a judge, I will have no problem with the ATC.
All right. The ATC, from an anonymous attendee, the ATC itself is creating fear among the people. The Congress should be designating them as terrorists. I don't think that needs your reply. If a government, this is from Vic Madarao, if a government official publicly threatens the people with a statement like, "Ipapapatay ko kayo," will this constitute a terrorist act? Did you hear that, sir? Shall I restate the question? Let me restate the question.
Yeah,
If a government, if a government official publicly threatens the people with a statement like, "Ipapapatay ko kayo," does this constitute a terrorist act?
well, there is a crime threat to commit terrorism, because ipapatay, you're not engaging in anything. You are threatening. You're threatened to commit. You are threatening to commit
Yes.
something that could become. So does that spread a message of fear? Does that create an atmosphere of fear among the people? Does that intimidate the general public? So if the judge says, oh, that is spreading, creating an atmosphere of fear, that is a threat to commit terrorism. That's why I think we should define this a little bit.
All right. Question from Chino Gaston. Can arrests and provisions exercised during the period while the law is being questioned before the Supreme Court be subject to litigation by the offended parties, say journalists or demonstrators who are arrested?
Well, their defense will be they can go up and question the constitutionality. They are directly affected, so they have a personality to question the constitutionality of the law. They can join the petitions in the Supreme Court.
Justice Carpio, we have a lot more questions, but I'm afraid we're running out of time. So last question from Gina Ordonez. What if the majority of Supreme Court is influenced by requirements of the palace? And besides, the powers of the Supreme Court takes a backseat when the ATC takes over. Is she correct there in saying that the powers of the Supreme Court will take a backseat when the ATC takes over?
I think there are a lot of speculations in the question. I don't think I have to answer that.
Okay, one last question. Question from Reggie Casas. If the bill becomes a law, will all the New People's Army, NPA, be automatically classified as terrorists and therefore arrested? How about the Communist Party of the Philippines, considering that it's not declared illegal right now, as I understand it? How about the Communist Party of the Philippines, continuous threat against democracy? Are they both classified as terrorists?
Well, the NPA and the Communist Party are engaged in rebellion because their purpose is different. Their purpose, rebellion, there is rebellion when you commit the same acts, but your intention is different. Your intention is to deprive the Congress or the President from exercising their powers. To remove the Philippines from allegiance to the Constitution. So that is rebellion. It's not just to instill fear, to create fear. Their purpose is to take over the government. That's why I said terrorism and rebellion are similar in the sense that the underlying acts may be the same, but the purposes are different. In rebellion, you want to take over the government, to remove the allegiance of the people to the government. In terrorism, you just want to terrorize, to create an atmosphere of fear. So for the NPA and the Communist Party, the NPA, they can be arrested anytime because they are rebels. They can be, for the promoters, for the leaders, maintainers, they can be charged with reclusion perpetua, rebellion with the penalty of reclusion perpetua. That's non-bailable. So there is no need for the anti-terrorism law to be applied to them because they are rebels already.
Well, thank you so much, Justice Carpio, for sharing your time and expertise with us today. We wish we could extend this webinar, but you know, time is gone. So to all the rest of you who have participated in this webinar, there is a second part of this with principal author of the law, Senator Ping Lacson. That's next Wednesday, June 14, from June 24 from 2 p.m. to 3:30 p.m. But before we adjourn, may I request our National Issue Committee Chair, Riza Mantaring, to give her closing remarks.
Risa, you're on mute.
Sorry about that. Okay, let me begin. This has certainly been an enlightening and thought-provoking afternoon. The anti-terrorism bill has sparked passionate defenses, both for and against it, and having someone as highly respected and who has repeatedly demonstrated both judicial integrity and courage in his decisions walk us through it has been an absolute honor. I cannot help but recall that when he retired, he was given all the honors due a Chief Justice of the Supreme Court because in the minds of the court, he was indeed a Chief Justice. We thank Justice CARPIO once again for accepting the invitation to speak before the MAP members and guests and for his patience in answering all the questions. As you can see from the number of questions, this is a topic that is of major concern to many people. And I'm certain that we are all coming away from this richer and more knowledgeable. The DILG asked for statements of support from local chief executives for the bill. And as of this afternoon, Secretary Año handed the President the list of governors and mayors who support it, close to 800. Given the issue cited by Justice Carpio, we hope that the President will consider all aspects in deciding whether to approve the bill or return it so that any defects can be corrected. So as Maan said, next week we will have the principal author of the bill as a speaker. Again, that's at June 24, 2 o'clock to 3:30 p.m. I invite everyone listening to this webinar to attend to that one too. And lastly, I'd like to thank Maan for doing such a stellar job of moderating the discussion as always. Thank you to all the attendees and participants, and good afternoon to everyone. That's it.
Thank you, everyone. Thank you.
Thank you, everyone.
Thank you all. See you next week.
See you next week.
Thank you. Very interesting.
Bye.
Really interesting.
Magaling ang galing.
Very
Yeah. Okay, thank you, Risa. Thank you, Maan. Thanks.
Thank you, Francis. Bye.
Thank you. Okay, thank you, Arnold. Thank you.
Thank you. Thank you.
Thank you.